Hello, my name is Megan Vistunbar, and I am a staff lawyer with the BC Law Institute. I am joining you today from the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I'm going to give an overview today of the consultation paper that the BCLI has put out on the Renovate the Public Hearing project. The BCLI is a nonprofit law reform agency in BC, and our work brings together academic, expert, and community collaborators to clarify and improve the law. So what are the goals of this project? Well, public hearings have been a part of legislation governing how municipalities and regional districts make land use decisions for many years. And while for a long time, there's been widespread belief that they serve a very valuable and important purpose, recently there's been increased criticism of how public hearings are not serving their intended purpose. So this project explores ways in which the law can change to better support other forms of public engagement and to provide a framework that honors the rights of Indigenous people. Public hearings are a requirement under provincial legislation when certain types of decisions are being made by local governments. Local governments are created by provincial legislation, and they're given authority to make certain decisions, but within parameters of certain rules. And on land use decisions, public hearings are the default form of public engagement that the legislation requires of local governments. The purpose of public hearings has largely been articulated through case law as opposed to the legislation. And the courts in BC have said that public hearings serve two main purposes. One is to improve the quality of land use decision-making by allowing for public deliberation on these decisions. The other is to give the public access to the same information as council or the regional board so that they can evaluate the impact of the proposed bylaw on their property rights. Recently, the BC government passed Bill 44, which expands on the exceptions to when public hearings are required. This legislation was passed after our committee developed the options in the consultation paper, but it doesn't really change the landscape significantly in terms of the issues that the BC Law Institute is seeking feedback on. And that's because Bill 44 will carving out some more situations in which public hearings are not to be held, still requires public hearings as the default form of engagement when an exception doesn't apply. And some of the key questions that remain and that are explored in our consultation paper are how could legislation better enable forms of public engagement? And how should local governments work with First Nations on land use decision making? So these are the issues that our committee considered and on which we are seeking input. By way of a little bit of background, the BCLI explores reforms to the law by working with an external project committee. In this case, we have a committee of planners, lawyers, and academics who bring together different expertise and perspectives in this area of law. And they have been exploring a wide range of ways in which the law could change. Now we're at a phase where we bring these options out for broader public input, and then we'll take that input back to our committee, and all of that helps them to form their final recommendations. I'm going to give a very high-level overview of what the committee has considered in respect of each of these issues, which are explored in a lot more depth in our consultation paper. I'd like to just point out that in terms of jurisdictional issues and Indigenous voices, this includes two broad issues. One is how could the law account for First Nations jurisdiction on land use decisions? And the other is how could public engagements by local governments be more inclusive of Indigenous voices generally? So right now, the property laws that underlie the authority of local governments to make decisions about land use come from the principles of English property law, as those have been adopted into BC laws. The current framework doesn't acknowledge or account for the inherent rights of Indigenous peoples to lands that they have traditionally owned, used, or occupied, as well as inherent rights to make decisions about those lands. In BC, about 95% of the land base is unceded territory, which means the inherent rights of First Nations rights and title holders have not been extinguished in relation to that land. The BC government has committed through the BC Declaration on the Rights of Indigenous Peoples Act to aligning BC laws with the UN Declaration on the Rights of Indigenous Peoples. So part of what our consultation explores is some of those jurisdictional issues, and they're set out as framing the background in the paper. In developing recommendations for reform, BCLI has been gathering input and perspectives from Indigenous peoples on this area of law. And one thing that we heard from quite a number of people is that there's a need for a framework at a provincial level for supporting shared decision-making as between First Nations and local governments. Currently, First Nations and their members are treated under the law as members of the public and not governments with decision-making jurisdiction. While some local governments are working more collaboratively with First Nations, it's not supported by the legislation. And in addition to that, BC courts have also held that municipalities do not need to consult with First Nations on these types of decisions. I think it's important to acknowledge that First Nations have called for legislation to require municipalities to implement the UN Declaration on the Rights of Indigenous Peoples in a number of contexts, not just in input on this particular project. So this quote on the screen now is from a resolution by the Union of BC Indian Chiefs to that effect. As well, many of the Truth and Reconciliation Commission's calls to actions speak to obligations of municipal governments, and we note some of those in more detail in the paper. These are just a few of the articles from the UN Declaration on the Rights of Indigenous Peoples that speak to the inherent rights of Indigenous peoples in relation to land and land use decisions. These are not taken verbatim from the text of UNDRIP, and it's also not a full or comprehensive list of all the land-based rights in UNDRIP. It is just intended to give some context to some of the rights that Indigenous peoples have in relation to land and decision-making jurisdiction. So some of the questions that we're seeking feedback on in this consultation relate to whether provincial legislation should distinguish between government level engagements with First Nations as rights and title holders from public engagements. The BCLI is also seeking feedback on how the legislation can support public engagements that are safer and more inclusive of Indigenous voices, including people who may be disconnected from their land-based nation. This goes in part to reconciliation considerations that local governments need to take into account, some of which are highlighted in the Truth and Reconciliation calls to action. So BCLI's project committee also considered how a statement of principles might inform this area of law. The current law that we have is very rules-based. It essentially says that local governments have to provide an opportunity for public input, and that is to happen in select situations, in a particular format, and at a particular time in the decision-making process. The BCLI looked at legislation in other places where they've moved away from this approach of being rules-based to a model that relies on principles of public engagement. From looking at other examples, our project committee developed this list of principles and core values that's on the screen right now. And they're seeking feedback on whether or not the law ought to move from being rules-based to being principles-based, and if so, what those principles should be. There are also many ways in which local governments can engage the public outside of just public hearings. And this is an area in which our partner, the SFU WASC Center for Dialogue, has been doing a lot of work. But if you're thinking about a new way of doing things, something else could be anything else. And our committee looked at some examples of other forms of public engagement, but there could be many more. And so another area in which we're seeking feedback is on what means local governments could employ for engaging the public and how provincial legislation can encourage those other forms of public engagement. And then there's the issue of the details, what those look like and who gets to decide them. One aspect of the details is simply when public engagements should take place in the decision-making process. Another aspect is how to make public engagements safer and more inclusive, particularly of voices that have often been excluded. As we have sought input from Indigenous peoples on the development of the options for law reform, it has been shared with us that this is something where a government-to-government arrangement could inform some of the details. So, for example, legislation could set out all of the details. It could also empower local governments to decide on the details. And it could support opportunities for local governments to work with First Nations rights and title holders in deciding those details. So we're seeking feedback on those details of public engagements, whether in relation to the timing or the structure as it is supported by legislation. So in summary, these are the key issues that we're seeking public input on in the context of the Renovate the Public Hearing consultation paper. How to support Indigenous voices informing the process, both at the governmental level and at the public engagement level. Whether to move from a rules-based approach to a principles-based approach. And if so, what principles ought to inform local government public engagements? Whether or not to continue to hold public hearings ever or sometimes. If they're held, when should they be held? And if not, what forms of engagement to hold instead? And the details of public engagements, from the timing to the structure, and how to make the process more inclusive of voices that are often excluded in the current framework. And we're not doing this work alone. So BCLI is undertaking this work in collaboration with the SFU WASC Center for Dialogue. So at the same time as we're exploring changes to the legislative framework for public hearings, the WASC Center for Dialogue is piloting changes to the public hearing process to learn what works on the ground. So we would love to hear from you on these various options for law reform. Please visit our website, bcli.org, for more information on the options for giving input, which include a survey, feedback booklet, and access to our consultation paper. Thank you.